Hello, my internet viewers. I'm excited to talk to you by this video on the topic of defamation, that is malicious prosecution. And IP section 499 defines reputation, and Indian Penal Code section 500 is a punishing sections. Plus, we have to keep in mind three sections of Criminal Procedure Code 1973. Those are sections 468, 469 and 470 for limitation. I'll talk to you in details about this. Please remember that suit for malicious prosecution lies in criminal court and suit for compensation damages lies in civil court. Now, ingredients of the malicious prosecution which you have to prove before the court. Number one, that the defendant initiated the proceeding against plaintiff. Next, that the proceeding terminated in plaintiff's favor and the way in which it was terminated. Next, that the prosecution was instituted against him without any reasonable or probable cause. I emphasize, this is the backbone of the case. You have to prove that the prosecution was instituted with a malicious intention, that is, not the mere intention of carrying the law into effect, but that an intention which was wrongful in point of fact. Last, did he suffer damage to his reputation or to the safety of person or to the security of his property? The burden of proving all these facts lies on the prosecution. Simply only one ingredient you are not to prove, that is, that the proceeding was terminated in plaintiff's favor and the way in which it was terminated, you can submit your acquittal order. It is proved. At the same time, you have to claim three types of damages. That is, damage to man's fame. Second, damage to his person. Third, damage to his property. If there was neither of these three sorts of damages, no action would lie. You have to prove at least one of them. Now I'll come to the limitation. When can you file a criminal complaint against a person? I'll refer citation of Supreme Court of India. I'll refer sections of Criminal Procedure Code. Of course, the law is very clear, but I'm also referring citation. Here, 1976 Supreme Court 986. Equivalent citation is 1978 Criminal Law Journal 764. Now, three sections 468, 469, 470. A complaint under Section 500 Penal Code for defamation will be barred if filed after 3 years after the commission of the offence. Subsection 1 of Section 469 of CRPC specifically provides that the period of limitation prescribed in 468 of CRPC in relation to an offence shall commence on the date of the offence. In short, the period of limitation for filing complaint under Section 500 Penal Code would commence from the date of the complaint and not from the date of the complaint was finally acquitted for the offence mentioned in the complaint. The point is, I'll clarify. Limitation period starts from the date of the offence or the date of the complaint, not from the date of acquittal. For example, Mr. A has initiated proceeding against you in a criminal court in the year 2000. Offence is committed somewhere in 2000, say November 2000. and you are acquitted from that case in 2010, after 10 years. After acquittal, can you file a criminal complaint? No, sir. So law is very clear that the period of limitation prescribed 468 CRPC in relation to an offence shall commence on the date of the offence, not from the date of acquittal. Now there are certain points you have to remember for proceeding. First of all, there has to be a prima facie evidence. The plaintiff is bound to give some evidence which will prima facie suggest absence of reasonable probable cause for malicious prosecution. Prima facie for what? Prima facie evidence for absence of reasonable and probable cause for malicious prosecution. In other words, Mr. A had invented story for the proceeding against you. Only judgments in rem, as defined in section 41 of Evidence Act, has binding effect on criminal court. Evidence of section 43. Judgment is not admissible to prove that plaintiff filed a false case. You are acquitted. It does not mean that it is a false case. The definition of false is something different. You are acquitted for lack of evidence. Section 43 of Evidence Act. The judgment of the criminal court can be used only to establish the fact that an acquittal has taken place as a fact in issue in a civil suit. The civil court cannot take into consideration the grounds of acquittal in a criminal court. The civil court should take an entirely independent inquiry before setting itself of the absence of reasonable and probable cause. For this, there has to be independent inquiry by the civil court, because question of compensation is there. Under section 300 of Criminal Procedure Code 1973, explanation is there. Action reads, the dismissal of complaint or the discharge of the accused is not an acquittal for the purpose of IPC section 500. Action would not lie if the complaint is dismissed under section 203 of CRPC 1973 without plaintiff having been summoned. This is very important. For example, Mr. A has filed a criminal complaint before the court. Learned magistrate has examined on oath. Thereafter, he heard his advocate, and immediately, under section 203 of CRPC, complaint is dismissed. In this case, can you file a criminal case for compensation or for malicious prosecution? No, sir, because accused was not summoned. This is the drawback. But if accused was sent a notice to appear and he has appeared before the court during the inquiry under section 202 and your complaint is dismissed under section 203 of CRPC, then prosecution lies. He can prosecute you. When accusation against the plaintiff was in respect of an offence which the defendant claimed to have seen to commit, what it says? Complaint says that I have seen this man personally for committing the offence. Case is filed. After trial, magistrate decides on merits and case is terminated. Person is acquitted. Then, can you file criminal case? Yes, because case is decided on merits and it has been proved that complaint was wrong. He gave the false statement. So, he can file a case. Now, joint action for damages. Joint action entails joint liability for damages, where all the defendants had a common object. Remember, common object should be there, and proceeded to assert the plaintiff. All of them are responsible for damages resulting from their joint action, although only 3 out of them took more prominent part than others and caused injuries to him, whatever may be. But there is a common object. common intention, common object. So all of them can be punished. All of them can be proceeded for malicious prosecution and compensation. So really, you have enjoyed this video. Share it and subscribe it. I express all of you from the bottom of my heart for joining with me in this video. Law is power. Use it, but don't misuse it. See you in the next video. Thank you.